Yeah, great. Hello, my name is Chris Hanford. I am, sorry, I am Director of Regulatory Policy at the Solicitors Regulation Authority. So it's great to be here at LEGALEX today. A real venue with real people makes a change, so it's great. Hope everyone's doing well and you all got in okay. I think I'm the first act on today for the Solicitors Regulation Authority at our theatre stage. So I'd like to welcome you all on behalf of the SRA. It's great that we can support this event and have our dedicated theatre stage again. We are action-packed programme over the next 2 days covering a wide range of stuff. So please do come and check out the other speakers. All sessions will be streamed on YouTube channels, so bear that in mind if you have comments and questions. We also have an exhibition stand, which is stand 572, which is kind of over that way. And colleagues will be manning that for the next 2 days, so please do call in and see them with any queries or issues that you want to discuss. I'll head there straight after this session, so you can talk to me there as well if you would like to. So I am here today to talk to you about the Solicitors Indemnity Fund and post 6-year insurance. We'll be launching a consultation on the future of Solicitors Indemnity Fund and post 6-year insurance in the next week or so. And I know this will mean a lot to some of you, perhaps not to all. So I'll start by giving a little bit of background about the Solicitors Indemnity Fund in particular. So quite a busy but fancy slide here, which sets out some of the history. So the Law Society set up the Solicitors Indemnity Fund in 1987. This was to provide the indemnity insurance, professional indemnity insurance cover for all solicitors and law firms in England and Wales. And it was funded by contributions from the profession and is administered by a separate company, Solicitors Indemnity Fund Limited. In September 2000, following a vote of Law Society members, a Solicitors Indemnity Fund was replaced by an open market insurance model, meaning that all solicitors and law firms bought their insurance, as they do now, from insurers on the open market, and the Solicitors Indemnity Fund was put into run-off. But then SIF does remain liable for historical claims, includes claims that were made during a period firms were covered by SIF, so from September 87 to August 2000, and claims made after 31st of August 2000 by law firms that closed without a successor practice on or before August 2000. So these historical liabilities will always be covered by some form of the SIF or an alternative arrangement. So in 2004, the Law Society also put in place a post 6-year run-off cover provision through the Solicitors Indemnity Fund for firms that closed after 2000, and this was funded with residual funds that had been built up from payments made by the profession. So there is not currently any payment made out of the practicing certificate fees towards Solicitors Indemnity Fund. It's just using residual funds. This arrangement, this provision for post 6-year run-off cover, was initially set to run until 30th of September 2017. Okay, so why is 6 years important? So 6 years cover. So 6 years is important as this is the period that all closing firms are covered under their open market arrangements with their insurers. That's the guaranteed provision. It's also the primary limitation period within which professional negligence claims must be made in the courts, although there are exceptions to this where it can be extended beyond 6 years in certain circumstances. It's also the length of time that most legal regulators require PII cover to be in place for, and also across other professional sectors as well. And this was the cover 6 years after a firm closed that the insurers were willing to provide on the open market when we moved to that in 2000. So we took responsibility for the Solicitors Indemnity Fund when we were established in 2006, along with all of the Law Society's regulatory functions. That was with the introduction, following the introduction of, or preempting the introduction of the Legal Services Act 2007, that required regulatory arrangements to be separated from representative functions. So the Solicitors Regulation Authority is responsible for those regulatory arrangements, including indemnity arrangements. So what has our position been on post 6-year run-off cover since then, and insurance more generally? So we set the minimum terms and conditions for insurance that firms must purchase, including the run-off cover provision when they close out successor practice, and this is also the what insurers are required to provide under the minimum terms and conditions. So we stuck with the position so far that was the Law Society's model when we moved to the open insurance market. So that requires the 6 years post 6-year run-off cover when a firm closes without a successor practice. In relation to post 6-year run-off cover and the Solicitors Indemnity Fund, we've extended that provision 3 times, and it's still there using residual funds. As I said, the profession is not currently paying anything extra for SIF. Following actuarial advice, SIFL's board, so the company that runs the SIF, has advised us that it cannot carry on as it is very much longer without additional funds. And our board has recently agreed to a final extension to 30th of September 2022 to allow a consultation on the scheme's future to provide certainty and the future of our post 6-year run-off cover requirements. So that's what we will be doing shortly, consulting on the future of the Solicitors Indemnity Fund and post 6-year run-off cover. Okay, so what are the key issues and questions? So, as I have said, under the existing open market insurance provisions, there's pretty full protection for consumers and for firms during the lifetime of a firm and for 6 years after they close without a successor practice. So we have a decision to make about whether we think that as a regulator, public interest regulator, we should provide or we should require ongoing post 6-year run-off cover within our regulatory arrangements past this current extension. And this is opposed to any kind of voluntary scheme, any kind of voluntary scheme that may be run and could be run by the profession and supported by the professional body. So on the next slide I'll talk about what we need to take into account in making this decision, our decision-making framework. So to frame the discussion, obviously we need to explore what post 6-year run-off cover arrangements could look like and who would pay for them going forward. So options could include carrying on with the Solicitors Indemnity Fund as is, and collecting further contributions, levying the profession to fund that on an ongoing basis. Solicitors Indemnity Fund is quite expensive to run, and as I said, it won't be sustainable with much longer without further contributions from the profession and further funding. We could look at some sort of indemnity fund or similar arrangements of a different kind, see whether there are cheaper alternative options out there. It's another possibility, although should flag that but by their nature this sort of cover is expensive. It's expensive to handle these long tail claims. There are issues such as the absence of records potentially, the need to locate the relevant solicitors long after they have stopped practicing, issues with establishing liability and limitation periods. We could also look to the insurance market, so look at whether there's a sort of master policy that might be available and the terms that might be available on. Or we could look at an open market solution where firms look to the open market to provide post 6-year run-off cover, and we consider whether we try and mandate that in some way. Although insurers have informed us, and we've heard that it's unlikely that all solicitors closing their firms as successor practice would be able to get insurance more than 6 years after they've closed, and a particular issue for firms that have already closed, solicitors that have already retired. There are other things to think about, such as whether, if there is cover, whether it should be for the whole of the profession or just for certain segments, and to protect all consumers or just certain segments of the consumers. And further funding would be needed in near term, so who would pay for that? All of the profession, or just those that are most likely to benefit from it on a risk basis? And we do know from historic claims data that there are certain areas of practice where most claims are concentrated. That's predominantly conveyancing and wills, trust and probate. We also know that claims tend to concentrate on smaller firms and sole practices. So these are some of the questions that we will be considering in consultation, some of the issues we'll be looking at, and which would very much welcome views on. So, as I mentioned, we have been developing and thinking about how we make this decision, and important to reflect on the purpose of post-6-year run-off cover as it's currently provided, and as our role as the regulator. So the purpose of post-6-year run-off cover is to provide cover for claims over and above the 6-year run-off period that's provided by the open market. And post-6-year run-off cover serves two principal purposes. So one is it provides continuity of client financial protection, which is principally a regulatory function. So no matter when a firm closes, a client of that firm would be able to be covered by insurance for any negligence that happened while the firm was open on an ongoing basis. The alternative without that insurance is that they would have to progress through the courts and try and seek redress from the individual solicitors, which is obviously a more complex and difficult way of doing it. It also provides security for retired solicitors, which is sometimes known as the sleep easy factor. And that's principally a representative function rather than a regulatory function. And that is an important distinction to make. So we exercise our regulatory functions for the benefit of the wider public, and any private benefits derived by individual solicitors and law firms from our regulation are incidental. And it is outside our remit in law and our establishing articles to act for the purpose of supporting or protecting members of the profession. That's predominantly a role for the Law Society as the representative body and the professional body of solicitors. And our Legal Services Act and other rules requires us to act independently of the Law Society, and we're required to enhance the separation between those representative and regulatory functions. So we do appreciate that potential removal of post-6-year run-off cover through SIF or another mechanism is of great concern to some solicitors. It would remove that sleep easy factor that I mentioned earlier, that allows solicitors to retire in the knowledge that they will be covered for claims against them relating to work that was done long before they gave up practice. So that's an issue for the predominantly representative body, and I'm sure it's considering steps it can take to support its members. It's for us to decide whether there's a regulatory rationale for the ongoing provision of post-6-year run-off cover in light of the consumer protection that it brings for that client protection. Our decision making, it must be grounded in the regulatory objectives that we've been set in legislation, in the Legal Services Act. They include protecting and promoting the interests of consumers, protecting and promoting the public interest, promoting competition in regulated services, improving access to justice, and encouraging an independent, strong, diverse and effective profession. The legislation also provides that we must have regard to the principles under which regulatory activities should be transparent, accountable, proportionate, consistent and targeted, as well as any other principle that we consider as represents best regulatory practice. So in our regulation, we need to balance the regulatory objectives and bear in mind the relevant principles to reach the best possible outcome, bearing in mind all of these considerations. So that doesn't mean that there'll be a zero failure regime. In our regulation, it's appropriate to have a degree of consumer risk alongside appropriate consumer protection. So a key consideration for us is the proportionality of any provision or requirement in terms of the cost to the profession, some at least of which is likely to be passed on to consumers of legal services, and given the number of consumers that will benefit and the value of redress. So we will be inviting views on consultation on this, as well as the impacts of different options on the relevant objectives and principles that I have set out. So what have we been doing to help inform the consultation and the analysis and options within that? Well, first of all, we have been looking at claims data and other information around who has historically benefited from post-6 year on-off cover provided through SIF. So the impact or if it wasn't there. And we've actually appointed a independent actuaries and insurance experts familiar with the SIF to analyse claim patterns and assess those impacts. We've also asked them to for their views on the viability and costs of different options in relation to the provision of post-6 year on-off cover that I mentioned earlier, and our intention is that we will publish that report alongside our consultation. We've also been looking at and talking to other professional services regulators to see what they do, what their run-off requirements are, and what they provide. So we will also provide information around that alongside the consultation. And we've also been talking to lots and lots of people. We've done lots of engagement. So that's included establishing a virtual reference group, which includes 29 delegates representing different segments of the profession, as representatives from law society, local law societies, and groups representing different segments. Also representatives from the insurance sector, and importantly the legal services consumer panel as well. We've also been polling those organisations and asking for their views on some of the questions that I've posed earlier to help inform the options and analysis that we have set out. Okay, so what are the next steps? Well, say there'll be a public consultation on this, which we will hope to launch any day now, and that will run for 12 weeks, so through to next year. We'll then make initial decisions based on the outcome of that consultation, and there may be a further consultation on any rule changes that may be necessary as a result of that. Any changes also require the approval of our oversight regulator, the Legal Services Board, and then we'll make sure that we are prepared and ready for September 2022, which as things stands is the current end date for the Solicitors Indemnity Fund providing this ongoing provision of post-6 year run-off cover. So a bit of an overview there. So say and background, say the consultation is to come, which will provide a lot of detail, sort of information and analysis, and we really do want to get views from as many people as possible in response to formal consultation. We'll also be doing lots of other engagement activity during the consultation process. So I am open to questions, I think, if anybody has questions. I think there's a mic at the back that can come round.
Hi there. I've listened to all of this, and all I'm seeing is, as the owner of a business, more problems coming our way. So, at the moment, for example, we're a two-partner practice with 12 employees, and we're paying £56,000 insurance with a no claims record and all the technology to reduce any risk for the insurer. I know of practices that are thinking of closing, and all I can hear while you're talking to me is about additional costs coming our way when this goes. And I'm not sure if everyone can understand the pressure that's on practices and keeps getting piled on, and now we might end up having to give away whatever we did earn on a claim when we've retired. I mean, it's just, I'm struggling to see why we're not getting more protection and assistance in what we're doing, because it's becoming near pointless, genuinely.
So, sorry, that's very loud, isn't it? Sorry, I do appreciate that that position. Have we got, is there sound? No? Yeah, is it through the headphones? Okay, I do appreciate that position. Do appreciate the cost pressures that are on firms and the insurance market at the moment. This consultation, one of the key things we're considering is that balance between costs to the profession of different options for post-60 run-off cover, and whether it's needed at all in that context, or should be provided or mandated by us at all, given those different pressures and the balancing that needs to happen. So we are very alive to this. That's one of the key themes that we'll be exploring in the consultation, and really would welcome views on this from the profession in exactly the context that you've set out. Any other questions at all? No? So I will be going to our stand over there. So if anybody wants to come and talk to me away from the public arena, then I'll be welcome those discussions. So please do come and say hello. Thank you all very much.